Good morning. Today we are going to be talking about recreational marijuana and the impact that it has had on our workplaces, as well as best practices for our HR listeners. Welcome to Off the Clock, the webcast of employment attorneys at Miller Johnson, where we discuss what is happening in the HR world and provide practical insight and advice.
Sarah, in the past 10 years, there's not a lot of things that have changed more, I don't think societally, than the acceptance of marijuana, right?
Oh, I completely agree. And what's fascinating is it really began with changes to local and state laws, right? First, allowing use of marijuana for medical purposes primarily, right?
Yeah.
And then expanding it to recreational use. And now it's feeling like the use of marijuana is just so much more prevalent than I, as a 50-something individual in this country, would have ever imagined or comprehended. And I'll just add, we know that workplaces are microcosms, right? Of course.
Yes.
Of what is happening in the outside world. So I know that all of that, the dispensaries that we see popping up every other day.
Yeah, so it is, as you mentioned, recreational marijuana is now legal, not everywhere yet, but in most places.
Yeah, there's
our listeners and watchers
yesterday I counted, and there remain only 6 states that don't have some legal use of marijuana. Right.
Still an unlawful controlled substance
not
under federal
allowed
law.
For medical. Yes, exactly.
Let's not forget that, because I know whenever we talk about this, a client will point that out and how that impacts.
Still illegal under federal law.
Yep. And that is where I think a lot of our clients started when this, I don't know if we call it a movement or a shift in acceptance of recreational marijuana, but when it started, clients changed policies, and many of them, at least in my experience, I'd love to hear yours. In my experience, many clients chose to keep their policies largely as they were, continuing to prohibit positive marijuana tests, right? Whether people were under the influence at work or not. So no marijuana at any time, but they amended their policy to make sure it was clear that marijuana was still prohibited because it was still prohibited under federal law.
That's exactly
So there'd be no confusion.
Right. That's what I saw as well. In other words, employers having a policy that essentially says if you test positive for marijuana, that will be considered a violation of the policy.
Yep.
And they would say, understand that that's the case for marijuana, just so you're not confused, because marijuana is still illegal under federal law, even though you may work in a state that allows use for this purpose, it still violates our policy.
So that's where we started.
Yes, that was the first step, and now we're seeing other changes.
As society has continued to evolve and become more and more accepting, I've seen an increase in clients calling to say, should we really still exclude people from employment who test positive, right, and pre-employment? Should we even include it in our testing panel? And just more generally, the attitude of we really don't care what you're doing on your own time, similar to alcohol, right? We don't care what you're doing with marijuana or alcohol after work or on the weekends. We just don't want you to be under the influence here. Have you seen the same trend with clients you speak with?
Same trend, but really so far, more specifically to pre-employment testing, right? So the idea that, don't forget, we're talking about a person that doesn't even work for the organization yet, right? It's not a huge leap for the HR or for the business to say, look, if this person legally used marijuana in this state last week, that does not automatically disqualify them from being employed here. Yeah. And of course, that is coupled with a really challenging market in terms of finding qualified individuals to fill important roles. Of course, and I will add that some positions would continue to find that relevant, and there are safety sensitive positions, et cetera. But
And some have to be drug-free, right? Because they are federal contractors, for
correct.
instance.
And so for drivers and federal contractors, there are exceptions. Yep. But when we're talking about maybe a production associate position, working in retail, working in a restaurant, et cetera, yes, I'm hearing many employers talk about and ask about removing marijuana either from the pre-employment panel or just ignoring the result and being willing to hire that person regardless of the test. And I think it's important to point out, as of now, marijuana testing tests only for use, meaning it tells you that somebody used marijuana. It does not test for present impairment from marijuana, right? So we've got a useful tool called a breathalyzer that can tell us if somebody is under the influence of alcohol.
Right.
We don't currently have that for marijuana. And then in addition to that, when the testing is done through a urine test, which most pre-employment screenings are done, the window of use is quite big, right?
Yep.
It's days and sometimes even weeks.
Yes. And so a lot of employers, again, just a shoulder shrug when they get that positive test back and think, I don't know if I really care that someone smoked pot or had an edible a month ago.
Right.
Right?
Yes.
I'm just not sure how that's relevant to my evaluation of whether they can do the job well or safely. So you and I both have lots of these conversations with employers, right? Should we continue to test? Should we not? And that is often where the client thinks the conversation will end, but it shouldn't be where it ends.
And they should know us better than that, right?
We know why you thought you were calling.
That's right.
Now we'll tell you why you should have called. I mean, obviously we have that conversation, and that's an important conversation to have. And HR obviously needs to have all the pros and cons, come up with a recommendation, right? Run it through the rest of leadership, make sure everyone is in alignment, right? But the conversation should not stop there, right? It has to move on. Okay, so now we know there is an increased likelihood that we will have employees who ingest,
who use
I can't
marijuana.
even say,
who
use it in many different ways, right?
Sure.
Who are going to be people that use marijuana, whether edible, vaping, smoking. I think that's also led to the increase, by the way. There's so many more ways, right? That aren't stinky, et cetera. How are we going to manage a workforce, right, where we've gone from 0% users to whatever percent, and I don't know, but more than zero, right, will be marijuana users?
That's exactly right. And that really, in my mind, is the important part of the conversation, right? So if you're not going to test pre-employment, you have to assume that now you are going to have a workplace with more users of marijuana than you did in the past, right? Sure. And so what does that mean for your business? Are you going to continue to have a policy that says you're in violation of the policy if you ever test positive, for example?
Yeah. Well, can we just go back to basics for just a second?
Sure.
Because sometimes we get excited. But I have had the question, before I jump into the specific question, I'll say, and I mentioned this to you before we started recording, this topic, when it comes to marijuana, it seems like sometimes people forget the basics, kind of like with COVID, people, just got ramped up about COVID, right, and skipped past basic FMLA and basic ADA principles. I see the same thing happening with marijuana. I can't really explain it, but I see it happening. Because very smart HR leaders have asked me, if we stop doing the pre-employment testing, can we prohibit people from being under the influence of marijuana or possessing it at work?
Right.
So let's just start with that basic principle. And of course, the answer is yes.
Of course. And yes, absolutely. And in fact, at least in Michigan, we're going to talk next time about different state laws that may change the answer to some.
Right.
At least in Michigan, you can employers can continue to have whatever policy they want with regard to current employees, right?
You can still
Now, the want
prohibit.
part is the important part, right? So if there's going to be a decision made with regard to pre-employment testing, in my opinion, you've got to also make the second decision, which is going to be, how are you going to handle current employment testing? Okay.
Right.
And is it going to continue to be the case that any positive test, regardless of when they ingested it, regardless of whether we believe they were under the influence at work or not, will be a violation of the policy? You can do that in Michigan if you want, okay? But if you are going to do that, you had better make that clear.
Yes.
Because that's very confusing to the person who just got hired.
Right. I thought you didn't mind.
I thought you didn't mind. I tested positive pre-employment. You knew, you hired me knowing that I'm a user of marijuana potentially, right? If there was a positive test.
Yep.
And now you're telling me that you're going to test me after you hire me?
Right.
And potentially fire me for testing positive, right? So we've got to make that second decision, that second policy decision with regard to current employment as well. And we've got to make sure whatever that expectation and that policy is clear to that employee, right? And I'm even recommending that employers take an additional step if they remove pre-employment testing after deciding what their policy is and rules are. They say that out loud to new hires, right? They're very direct about it, right? We
don't want to trick people.
What are the rules, right? Yeah. For example, if we decide we don't prohibit legal off-duty use of marijuana, so long as you never possess it, use it, or are under the influence at work. If that's going to be your rule, that's what your policy should say. And that's what you should explicitly tell new hires. And because we're lawyers, we would love them to even sign off on something saying that. So everybody understands what the rules and standards are.
The tricky part here, which you've already mentioned, is that the tests don't tell us if someone is impaired at work.
Right.
So for employers that want to take a bright line and say, when we test, if it comes back positive, it's not going to tell us whether you were under the influence at work. We will terminate your employment for any positive test. That should go into the same policy, if that is the policy of the employer.
Correct.
And they can do that.
They can.
We get those calls, right?
They can in Michigan, yes. Not in some states.
Okay.
And again, we'll talk about another teaser for next time. We're going to be talking about that more. But I would add a couple of pieces of advice to that as well, right? Because you are exactly right. This conundrum with regard to pre-hire testing is just as present with regard to testing of current employees after we hire them. Right. In other words, if we just send somebody for testing, particularly urine testing, and we have no context as to whether or not we thought they were under the influence when they were at work, you could get a positive test and really not know what to do about it.
That is exactly
we don't know. We don't know.
And the employee says it was from last weekend.
Correct.
You'll ask the employee, and the employee will say it was from last weekend, and then you'll call us and ask, how do I know?
And I will tell you from lots of conversations that I've had, right, for the same reasons that that business might have eliminated pre-employment testing, they may not be excited about ending somebody's employment for a test that may not have any relevance to them at work, right?
What's the answer?
I have ideas.
You're so modest.
Yeah, right. The first one,
ideas for answers.
The first one is, and I'll just say this, I truly believe that every workplace is going to be moving to a model of reasonable suspicion. And I highly recommend HR folks get on board with that sooner rather than later. And by that, I mean, before we send anybody for a drug test, we go through a process to determine whether or not they appear to be under the influence of a controlled substance for which they might later test positive, right? That's something that has been done here and there, usually because we already think somebody might be under the influence, or for certain drivers, DOT requirements, that it's done in that context as well.
Yeah.
But I think that is going to become standard in workplaces, right?
I completely agree. And I have worked with clients, and I know you have too, with reasonable suspicion standards, articulating the standard in policies, because that can get people into circles, right? Thinking about, the burden of proof and beyond a reasonable doubt and all of these legal phrases people have heard over the years. I like to think of reasonable suspicion as any, so it doesn't have to be a certain weight, right? But any objective observation or information that could indicate impairment.
That's right.
Doesn't prove impairment, but could indicate
it has to be
impairment. What do you think? How do you explain
I
it?
agree. And that's, number one, that it's reasonable, right? The word is reasonable, right? If there has to be some sort of connection. We're not going to say because so-and-so is wearing a blue shirt, we think he or she has used alcohol or marijuana before work, right? But on the other hand, if they're stumbling or their eyes are red or they appear, there's physical manifestations, they smell of marijuana,
the telltale odor.
For example, right, exactly. Then those are reasonable considerations. And the other part of it is suspicion, right? We're not saying we know for sure. We're not saying we can prove it. We're saying we suspect.
Yes, that is where a lot of people get hung up. And when I think of reasonable, I like to maybe replace that word sometimes with objective.
Yeah.
Like, so when a manager or a supervisor calls HR and they say, can you send so-and-so for testing, right? I think they might be high. I think they might be under the influence, frankly. I think they might be drunk, right? Whatever it is, the response from HR should always be, what makes you think that? Right? And get to the point where you have an observation that makes sense. That observation is traditionally tied to possible impairment.
And I think really now we are at a place in which employers should have a much more robust process. They should have an actual written policy. They should have a procedure that's in writing. They should have a checklist so that everybody who does it are considering all the same factors and characteristics. And most importantly, it's got to involve training, right? So employers should select which leader or HR representative is equipped to be able to do the analysis and train those individuals so that they can do it. So that's the first part. And imagine, Rebecca, then let's take an example, and let's say an employee is getting sent for testing after a workplace accident, right? That's one of the situations that really raise issues in this context, right?
Can being in an accident alone be reasonable suspicion?
I don't think so.
Putting you on the spot.
I don't think so. An accident, I feel like I'm parsing words at this, right? But an accident is after all an accident, right? So I would assume when you use that word, it doesn't appear that there's anyone to blame.
I've certainly gotten that question.
Yes.
And let's not forget the workers' comp aspect, that many workers' comp policies and providers will require you to send, to send for testing after an accident, by the way. So what we're talking about is outside of that requirement.
So let's take that example, and let's say employees getting sent for testing after an accident because that's our standard process. We can do that. And let's imagine then we don't do any analysis as to whether they appear to be under the influence. We send them for a urine test. It's positive. That's when our wonderful HR folks wring their hands and say, I don't know what to do.
Right.
Does it violate the policy? I'm not really sure anymore if it does or not. They're saying they weren't under the influence, et cetera.
I'm still not sure if they were impaired at work.
Imagine, though, if before sending them for testing, we had engaged in that reasonable suspicion analysis, and there was a checklist, and somebody trained had observed that person and had determined that they did or did not appear to be under the influence of anything.
Yeah.
Right? Imagine if you had that information then in hand when you got the test result back. Wouldn't it be so much easier to be able to interpret that result? For example, if there were evidence that that person was under the influence, or indication, I should say, and the test came back positive for marijuana. Well, that certainly makes that decision feel easier.
Correct.
Right?
Yep. Absolutely.
And equally so if there was no indication whatsoever that the person was under the influence, and they say they did not use it at work and were not under the influence, then that also makes that decision feel better, right? It's easier to believe them when they tell us that. So, like I said, I really think reasonable suspicion training and programs in the next few years are going to be something that just about every employer is doing by necessity.
Got
it. The other piece is that I would encourage our listeners to really be paying attention to the innovations in testing now. This is a problem that is not born just by workplaces.
Right.
Law enforcement faces this problem, and in our country, when there is a problem, eventually there is what?
Money.
A solution, right? Exactly.
A solution that people charge money for.
And so we are beginning to see testing that still doesn't test for impairment, but it very much narrows the window of use. So, for example, we now have saliva testing that can narrow that window of use to 4 to 6 hours, to between 4 and 6 hours. Well, that helps us tremendously, right? Imagine if somebody got tested at the end of their shift,
right,
on a saliva test.
Right.
That's very helpful. So those two things together, right, the reasonable suspicion and the innovations in testing, I do think are going to help employers manage this issue for current employees as well.
And as we're talking about innovations, I became aware of an innovation, a technology that measures potential impairment by reaction time on cell phones, which is really cool, right? Because then that takes out the checklist issue, the training issue. You still maybe have to take those things into mind, but when someone repeatedly tries, right, a reaction time test and it's repeatedly below their baseline, that is very good.
Sure.
Reasonable suspicion. Not necessarily that they are under the influence of marijuana, but something is going on, whether it be marijuana, alcohol, exhaustion, something that is making it unsafe, frankly, for that person to be doing their job. So there's innovations all over the place here to help employers make good, sound decisions.
All right. Well, this is probably enough conversation on this issue today. Next time, we are going to be talking more about different laws that can limit when an employer can take employment action based on use of marijuana.
So this will include various state laws, but also everyone's favorite, the ADA reasonable accommodation question.
And where we sit with that.
Do we have to accommodate employees who have medical marijuana cards?
All right. Looking forward to that, Rebecca.
See you then.
Okay.